Most people believe the biggest threat to losing a home is foreclosure, unpaid taxes, or some kind of financial collapse. But for thousands of families every year, the real problem begins after the funeral, inside a quiet phone call they never expected to receive. A title company calls, or an attorney, or a probate clerk. And suddenly, the surviving spouse learns something terrifying. The house they thought automatically became theirs legally didn't. Not because of fraud, not because someone stole it, but because two words were never added to the deed. Two ordinary words that most people have never even heard of. Yet those words can determine whether a widow keeps full ownership of her home or ends up sharing it with stepchildren, creditors, or the probate court itself. And the worst part is this usually happens to families who thought they had done everything right. For decades, millions of married couples across America bought homes together under the assumption that if one spouse died, the other would naturally become the sole owner. That assumption feels logical. After all, they paid the mortgage together, lived there together, raised children there, celebrated birthdays there, and in many cases spent 30 or 40 years building equity together. Most couples never imagined that ownership could fracture the moment one spouse dies. But in a surprising number of states, that is exactly what happens when the deed does not contain the precise survivorship language required under current law. The phrase at the center of the problem is with right of survivorship. In some deeds it appears fully written out. In others it may appear as an abbreviation like ROSE. Older deeds sometimes use language such as to them jointly and to the survivor of them. But if the legally required survivorship wording is missing, ownership often defaults to something called tenancy in common. And under tenancy in common, when one spouse dies, their share of the property does not automatically transfer to the surviving spouse. Instead, that share becomes part of the deceased spouse's estate and must pass through probate. That sounds technical and harmless until families discover what it actually means in real life. Imagine a husband and wife who bought their home in 1986. They spent decades paying it off. By retirement, the house became their largest asset. Maybe it's worth $600,000 now, maybe more. They assume the surviving spouse will automatically inherit everything because that is how marriage works in their minds. Then, one spouse dies. A few months later, the surviving spouse tries to refinance, take out a home equity loan, or sell the property. That is when the title company discovers the deed never included survivorship language. Suddenly, half the property belongs not to the surviving spouse, but to the deceased spouse's estate, and that estate now enters probate court. The consequences become even more severe in blended families. If the deceased spouse had children from a previous marriage, those children may legally inherit part of the house. The surviving spouse can end up co-owning the home with stepchildren who may have completely different financial interests. Some cooperate, some do not. Some need money urgently. Some see the inherited share as an investment opportunity, and some simply refuse to sign anything at all. This is the moment families realize the emotional idea of ownership and the legal reality of ownership are not the same thing. The law surrounding survivorship rights is not new. These rules have existed in American property law for generations. But the details vary dramatically from state to state, and many states changed their statutes over the past several decades. That means a deed recorded in the 1970s or 1980s may no longer produce the legal effect the original owners believed it would. In several states, older forms of joint ownership once carried an implied survivorship assumption. Couples could simply be listed as joint tenants, and courts often interpreted that as survivorship ownership, but many states later abolished that automatic presumption through statute. Now the survivorship wording must appear explicitly. The legal effect of the deed changed, even though the paper itself never changed. The distinction between joint tenancy with right of survivorship and tenancy in common is one of the most important concepts in property law, yet most homeowners have never heard either term explained clearly. Under joint tenancy with right of survivorship, ownership transfers automatically when one owner dies. Probate is bypassed entirely for the property itself. The surviving spouse simply records a death certificate and, in some states, a short affidavit. Ownership transfers by operation of law, fast, clean. private. Under tenancy in common, each owner possesses a separate fractional interest. Usually that means 50% each between spouses, but when one spouse dies, their 50% does not vanish into the surviving spouse's ownership. It becomes part of the estate. The will controls it, or if there is no will, state intestacy law controls it. That difference can completely transform the financial future of a surviving spouse. Consider what happens in the simplest probate scenario. A husband dies, leaving a will that gives everything to his wife. The probate process still must occur because his half of the house belongs to the estate. Court filings begin. Notice periods open. Creditors may file claims. Attorneys become involved. Months pass. Sometimes more than a year passes. Even when the surviving spouse ultimately inherits the property, probate expenses can easily consume $15,000 to $30,000, and that is considered the easy version. One widow in Ohio discovered this reality after her husband died following 41 years of marriage. Their deed, recorded in the mid-1980s, identified them as joint tenants but never included survivorship language. Under Ohio law, that ownership structure defaulted to tenancy in common. Her husband had written a will decades earlier and never updated it after major life changes. The will divided his estate among his children, including 2 children from his first marriage. When probate concluded, the widow still owned her original half of the home, but portions of her late husband's share now belonged to his children from the first marriage. She could remain in the home under homestead protections, but she no longer controlled the property entirely. She could not refinance. She could not access the equity. She could not sell without the signatures of the other owners. One child refused to sign away the inherited interest because of financial hardship in his own life. Another demanded compensation. The widow suddenly found herself asset-rich on paper, but trapped financially in reality. The house she lived in for decades became partially controlled by people with different priorities and different needs. Situations like this often spiral into partition litigation. A partition action allows one co-owner to ask the court to force the sale of jointly owned property. If owners cannot agree on what to do with the home, the court can order the property sold and distribute proceeds according to ownership percentages. Partition lawsuits are brutal financially and emotionally. They often last years. Legal fees climb rapidly. And because the sales are frequently distressed or court supervised, homes may sell below market value. Families that once gathered together for holidays suddenly communicate only through attorneys. California, for example, allows community property with right of survivorship and community property without survivorship. Those are legally different structures with different inheritance consequences. Texas also requires specific survivorship language for certain transfers between spouses. Washington often relies on separate community property agreements. Meanwhile, the remaining common law states follow entirely different frameworks. Some still preserve limited presumptions favoring survivorship ownership. Others abolished those presumptions completely decades ago, and many operate somewhere in the middle depending on deed language, marital status, and recording dates. Older deeds frequently contain dense legal wording that non-lawyers struggle to interpret. One phrase may preserve survivorship rights, while another nearly identical phrase does not. A difference of only 5 or 6 words can determine whether a surviving spouse keeps complete ownership or enters years of probate complications. That is why attorneys who regularly handle estate planning or real estate matters often recommend a formal deed review. In many cases, an experienced attorney can determine within minutes whether the deed language satisfies current state law. The correction itself is usually straightforward. It usually happens quietly, not during a dramatic courtroom battle, not during some public legal showdown. It happens in ordinary moments. A refinance application, a sale attempt, a meeting with a title company, a widow sitting at a kitchen table after the funeral believing the house is already hers. Then comes the phone call explaining that legally things are more complicated. The tragedy is that most of these families were not irresponsible. They paid their bills, maintained the property, stayed married for decades, trusted the paperwork they signed years earlier. They simply never realized that 2 missing words inside a deed could override decades of assumptions. And because property law changes slowly and silently, many people still have no idea their deed may no longer function under modern statutes the way it once did. Yet the transfer of that asset often depends on technical legal wording buried inside documents nobody has reviewed for decades. The correction is usually inexpensive, the failure can cost a fortune, and the difference between those outcomes may come down to two words most homeowners have never thought to look for: with survivorship.